Tonight, we're talking about freedom. Not the kind promised in speeches, but the kind that matters after arrest. Nearly half of Kenya's prison population is made up of pre-trial detainees, people who have not been convicted of any crime, people who are waiting for trial. And for some, the difference between waiting at home and waiting behind bars often comes down to one thing: money. So tonight we ask, is freedom in Kenya a legal right or a financial privilege? Let's unpack it. Let's talk about bail, bonds, and freedom. About what happens after arrest and why, for many Kenyans, freedom has a price tag. The Interior Ministry data indicates that 48% of Kenya's prison population is made up of pre-trial detainees, people who have not been convicted of any crime. They're not serving any sentences, they're waiting.
This number keeps on rising, sometimes from 40 to upwards of 50–60%.
They're waiting for trial, waiting for hearing dates, waiting for justice.
It certainly is an area of concern for us as the judiciary, because those numbers are really too high. And what we have done is to work together with the other agencies, like the prisons, just to see how do we decongest.
When someone is arrested, it doesn't automatically mean they're guilty. It means they are suspected of committing an offense and are taken into police custody. Under Article 49 of the Constitution of Kenya, an arrested person must be brought before a court as soon as reasonably possible, legally within 24 hours. At that moment, one principle should guide everything. The law is expected to treat you as innocent until proven guilty. Think of this stage as the waiting room of justice. You have two options: cash bail or bond, which allow you to go home while your case continues, or remand, which means waiting behind bars. Cash bail is like a refundable deposit. If you attend your court hearings, you get that money back. Bond works slightly different. Instead of paying everything up front, you sign a commitment to pay a specified amount if you fail to appear in court. Courts may also require a surety, which is someone who guarantees you will attend.
There are very specific cases where somebody can just go and say, this accused person was asked for a bail of 5,000. They were not able to raise it. It was reduced to 3,000. They were still not able to raise it. The court can ask, do you know somebody who is employed somewhere, who can come and give us their pay slip to confirm that they're employed somewhere and that can stand surety for you?
If bail or bond is not granted or the amount set cannot be raised, the accused remains in remand. That means detention before conviction.
The main reason why we actually have bail is to secure the attendance of the accused person to court, because without an accused person, then the trial cannot proceed. So if there is any reason that would make the court suspect that this accused person would not attend court, then that becomes a very huge reason. So for example, if the accused person is a flight risk, the law now has actually been promulgated to ensure that even victims' rights are also considered. If this person is going to interfere with a witness, going to interfere or threaten a victim, if they're going to interfere with investigations, such like reasons.
In many offenses considered to be minor, bail is granted. The real issue often lies not in whether bail is allowed, but in the amount set. Courts say the guiding principle is that bail conditions must be reasonable.
You look at what the Constitution talks about. It talks about reasonable conditions. And I think that we have had an extremely high reliance on cash bond, and the other alternative being titles, logbooks, and civil servants' pay slips, and you find that those are inadequately covered because not many of the accused persons have either a title deed or a logbook.
Critics argue the system is designed to punish poverty. Poverty itself is not illegal, but many activities termed as being survival-driven are and get people arrested. Loitering, street vending at unauthorized places, public nuisance, failure to pay small fines.
If you arrest a person who is maybe a casual worker earning 300 or 500 per day, he's able to provide for his family. But if you give him a bond of 1,000, he's unable to pay it because he earns 300 every day and he does not have savings, but he has enough to feed his family every day. So once he is unable to report to work for 2 or 3 days, he loses his job. So when he comes out into a different cycle of poverty.
Hakuna mtu hapa akona pesa ya kutoa ati 100,000.
And when bail is set beyond reach, detention can sometimes last longer than the sentence itself would have.
Somebody should not be detained if the punishment for the crime upon which they are being in pretrial detention is punishable by way of a fine only or to imprisonment of less than 6 months.
Is it possible that some bail decisions are meant to discourage similar offenses?
It depends from case to case, depends on the circumstances, depends on public interest. So it is really amalgamation of issues. It is not just one issue, and it is definitely not supposed to be a deterrent, for other people, because at this point, the person is presumed innocent.
And with court backlogs and staffing constraints, is every bail decision given the depth of consideration it requires?
We have 600 and about 50 magistrates in the whole country, across our 145 court stations. The average number of cases that a magistrate handles per year is over 1,200, one individual. For a judge, it is about 800 cases per individual. So you can imagine those numbers for you to be able to deal, properly listen to the matter, determine the issues. I mean, that is quite some workload.
So as Kenya debates justice reforms, we must ask, is freedom in Kenya a legal right or a financial privilege?
When, there are offenses that have been committed, it doesn't matter who has committed them. The whole reason is that you will attend court. So in as much as we empathize with those that may not be able to raise, we have to look at how do we balance this, the public interest versus the rights of the accused person.
The Constitution says you are innocent until proven guilty. Bail was meant to be a bridge between arrest and trial. But when that bridge can only be crossed with cash, it begins to look less like a bridge and more like a barrier. And that is not what justice was designed to be.